Good morning. Are you Thelma Gilbert?
We're jumping into a courtroom packed with serious felony charges from identity theft to burglary and credit card abuse. But here's something many people don't realize. Before any plea deal is finalized, judges often have to weigh real-life circumstances alongside the law. Keep an eye on how compassion and justice collide in this next moment.
Answer out loud, please. And this is cause numbers 26 DCCR 0502, 03, 04, 05, 06, 07, and 08. Ms. Gilbert is charged with credit or debit card abuse in 4 of those cases, burglary of a habitation in a case, fraudulent use or possession of identifying information, as well as theft of property. And what is the announcement?
Judge, we've gotten a offer that will probably resolve this matter. It's going to involve a lengthy prison sentence. Our issue right now is day before yesterday, Ms. Gilbert's daughter and her father were involved in an auto accident, and they're being hospitalized in Dallas. So we're trying to find out, I guess, that's exactly what's going on with them. So she'll know basically the stability of her daughter before we do the agreement. So I'm just asking for a short setting so we can get that resolved, so we can move this case along, Judge.
I told Mr. Lewis I would hold that offer open if we got a reset for that reason at 89.
All right, I'll reset it one time for that.
Thank you, Judge.
You can go back with the bailiff. Thank you.
That was an important decision. The judge agreed to delay the case not because the charges became less serious, but because of a family emergency involving the defendant's daughter. It's a reminder that while courts enforce the law, judges also have discretion to consider extraordinary personal situations. Do you think this was the right call? Let me know below.
Tham,
Judge,
Mr. Lewis?
hold on that one.
Sure. Thank you. We'll hold that.
Hold on.
Justin Thomas, Mr. Lewis. Competency.
Yes,
He's confident now.
yeah, we just got him back.
Okay, so you'll just need some time.
Yes, ma'am.
Let me make this finding of competency and then
And I need to look into some kind of way while he was in the hospital there. I think he got a PR bond on one of the cases. I'm just trying to make the check, see where he came from. He gave me the paper. System.
Kelly, can you make a note to look into that? Yeah, please. All right, sir, you Justin Thomas? And I'm going to take judicial notice of the court's files and cause numbers 25 DCCR 0308 and 25 DCCR 1874.
Now we're seeing something completely different: competency restoration. In criminal court, a defendant can't stand trial unless they're mentally capable of understanding the proceedings and helping in their own defense. This isn't about guilt or innocence, it's about making sure the legal process is fair. Watch closely as the judge explains the medical finding.
Mr. Thomas was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for Competency Restoration. I've received that report dated June 16th of 2026. It includes the trial competency evaluation report, which is prepared by Dr. Guzman. The findings in that report is that he is currently competent, has achieved competency while he was there. Also in that packet is the attending physician's report to the court, and that is dated June 15th of 2026, prepared by Dr. Liberis, again with the finding that Mr. Thomas has achieved competency and is currently competent to stand trial. Is there anything else with regard to competency?
No, ma'am.
Then at this time, I am going to find that Mr. Thomas is competent to stand trial. My understanding is he just got back here, from John Dunn, and so I'm going to do a normal reset. That'll give you
Yes.
some time to visit with Mr. Thomas about any options, he has on his case. All right, so Mr. Thomas, Mr. Lewis will be out to see you very soon to go over everything with you, okay? All right, we can go back with the bailiff.
Thank you.
And then you've got, Jason Weinberg, it's the sentencing.
That's right. Weinberg. Weinberg, it's Weinberg. Smart.
Good morning, you're Jason Weinberg?
Yes.
And Mr. Weinberg was previously here and entered a plea of guilty in cause number 25 DCCR 1479 to the state jail felony offense of engaging in organized criminal activity. I've received that pre-sentence report. Have you both had an opportunity to review the report?
Yes, Your Honor, we have.
Any additions or corrections?
No, Judge.
Not from the state, Your Honor.
All right, Mr. Weinberg, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings. You'll be placed on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation.
Yes.
If you do that, this is a great opportunity. You're very young, you don't have a felony conviction on your record, and if you successfully complete this probation, you'll never have a felony conviction. At the end, the case gets dismissed. It's a
Yes.
great opportunity. The other side of that, though, is if you violate any condition of probation, you can be back here in court, found guilty, so you become a convicted felon, and you could go to the state jail prison for up to 2 years. Understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. Probation will talk to you probably before you leave. Good luck to you, sir.
That's one of the biggest opportunities a young defendant can receive a deferred probation agreement. If everything is completed successfully, the felony conviction can be avoided. But there's a catch. One serious violation could erase that second chance and lead straight back to court. Would you risk throwing away an opportunity like this?
Thank you.
All right.
Thank you, Your Honor.
Thanks.
I'm sorry. Mm-mm. No, that was, we'll see. Since it's a state jail, she said no ISF for
Oh.
him. I said, no, we'll hopefully not need that. Not today. So, that DeMarcus Evelyn is gonna be Brittany handling that? Yes. And that's for a bond? Yes. Okay. Hi, good morning.
Howard County, so Tom, I can do a co-counsel. I'm just going to take on the back. That's what I have to do.
It is on Dalton Beach. Okay,
And congratulations.
I know, thank you.
Okay, y'all have a great day.
Thanks, you too. Let's see. I know, usually he at least stops by. Ms. Holmes, are you ready on Daniel Eli?
You may be a pro on Audubon's supposed to plea on, Audubon has his misdemeanor.
Oh,
He's
okay,
supposed to plea on the misdemeanor so that will dispose of the felony.
okay,
Can't find Audubon.
okay. Well, I'll hold it.
Okay.
Is he supposed to do it today?
Yeah.
Yes, they've always been set together.
Yeah,
It's been trying to get it all of the parties here.
okay.
And if
I'll hold it and
push comes to shove, Judge, I can do that today, if you allow me to put on the record, that if that does not.
and that's fine if we need, I mean, I can just reset it a week and then get them down there this week, but
Yeah,
maybe,
it just keeps going back and forth. I think,
yeah.
Unless they let me, step in, they let step in and they rest in.
See if you can get, y'all already tried to call Audwin this morning.
I have not.
See if y'all can get him on the phone, and if he's around, great. If not, see if he'll give you permission to do that.
Okay.
I'll hold it for now, though.
Oh,
And then you've got, Janaea Fine.
yes, sir. Wait. Yeah, that's the other one. That one, she should make another copy of.
Oh, okay.
Thank you.
Today's this. Good morning. Are you Janaea Fine?
Yes, ma'am. Yes, John.
Next up, another guilty plea, but don't assume sentencing happens immediately. In many felony cases, judges order a pre-sentence investigation, often called a PSI. That report gives the court a deeper look into the defendant's background, criminal history, and personal circumstances before deciding the final punishment. Sometimes that report can make a huge difference.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Ms. Fine, in clause number 26, DCCR 0432, you're charged with a second-degree felony offense of assault on a police officer from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then we have clause number 26 DCCR 0433. And in that case, you're charged with a third-degree felony offense of harassment of a public servant. And that's from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
And are you also pleading guilty in that case freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
In both of those cases, I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Fine is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Before we talk about the bond, there is only a fine in 0432 of $500. There's no fine in 0433. And so, Ms. Malfino, what's the state's position with regard to
No objection.
a bond? So, Ms. Fine, what I'm going to do in each of your cases, based on the nature of your plea agreements, is reduce your bond in each case to $1,000. I'm going to make those personal bonds, which means you don't even have to pay any money. You're just going to get released from jail today. But there's some very, very important things that have to happen between now and when you come back for sentencing, if you want me to go along with this deal. The first thing is that when you are released from custody, the very first thing you do is go to the probation department. You're going to get some papers today. It's going to tell you where to go. So you have to go straight there so they can start that process to get that report from you, okay?
Yes, John.
If you don't do that, then obviously a warrant could go out for your arrest. I don't have to follow this agreement. Things could be a whole lot worse. So it's very important that you do that, okay?
As long as the address on it, Yana, I'll go.
The address will be on it. You'll talk to a probation officer in the courtroom today before you leave, and she'll tell you everything you need to know about where to go, okay?
This ending highlights how every instruction from the judge matters. Receiving a personal bond isn't the finish line, it's the beginning of a long list of responsibilities. Missing even one requirement, like reporting to probation, could completely change the outcome. Justice isn't only about the sentence handed down in court, it's also about whether someone takes advantage of the second chance they've been given. If you've made it this far, tell me in the comments, should courts continue offering opportunities like these, or should repeat offenders face stricter consequences?
The next thing is that you cannot get in any trouble or arrested for anything between now and when you come back. If you get arrested for anything, you run the risk of me raising your bond, or you'd be back in here and I don't have to follow this agreement. You understand?
Yes, John.
All right, you can go back with the bailiff. We'll
Thank
see you
you.
at sentencing. Anthony James, Ms. Holmes,
You can hold that one.
Sure.
1 minute.
and then what about Michael Spain?
It's a test.